Hi, I'm Olivia Casillas, and I'm going to teach you about copyright and copyright evolution today. You might be wondering, what is copyright? Copyright is the legal ownership of a musical composition or sound recording. Musical compositions and sound recordings are two separate works for copyright and may be independently enforced and licensed. Musical compositions typically are printed onto paper, while a sound recording is the unique recording of a musician's interpretation of the song. The 1972 Act added sound recordings to copyright laws because before then, people didn't think of it, they only considered songs. The Copyright Act of 1976 defines sound recordings as works that result from the fixation of a series of musical, spoken, or other sounds, but not including sounds accompanying a motion picture or other audiovisual works. In general, music publishers own or control the musical work copyright, and record companies own or control the sound recording copyright. Copyright protects original works created for a creative purpose. To be eligible for copyright protection, the work must be original, made into tangible form, and display any form of creativity. For example, as soon as an original song is written down as sheet music or recorded as a computer sound file, a copyright is created. It is not necessary to publish the song or register a copyright with the U.S. Copyright Office. However, registration is required to obtain certain benefits under the Copyright Act. Creative works that are entitled to copyright protection are music works, sound recordings, literary works, pictorial works, motion pictures, dramatic works, architecture, and software. However, copyright does not protect ideas, inventions, logos, band names, slogans, or many more different properties. Other types of intellectual properties protect these creations. Patents protect inventions, methods, systems, and processes, while trademarks protect symbols, designs, names, slogans, logos, and characters. The bundle of rights are known as the 5 basic rights exclusively controlled by the copyright owner. These 5 rights are the right to reproduce, the right to make derivative works, the right to distribute publicly, the right to perform publicly, and the right to display publicly. Right to reproduce entails that no one other than the copyright owner may make any reproductions or copies of the work. An example of this right would be that another artist cannot incorporate a portion of a published song or into a new song. Derivative work kind of overlaps the right to reproduce because it gives owners the right to transform and adapt their work to something else. An example of this would be the copyright owner taking the recording and remixing it with new elements. The right to distribute publicly allows copyright owners to sell, lease, rent, and lend their creative works for a profit. The right to perform publicly allows owners to control when their work will be performed to large audiences, whether that be on television or a live performance. The right to display publicly is similar to the right to perform. However, it includes all forms of online and public display. However, if an individual or company would like to use one of these rights, they need a limited permission agreement, known as a license. It is also extremely important to receive an exclusive license. Unlike a non-exclusive license, exclusive license must be in writing. Therefore, there is evidence on the exact agreement and no one will take advantage of you. A license includes all the rules, fees, restrictions, and expiration date which the license holder can use the owner's property. It includes how and to what extent they can use their work and only includes what is explicitly stated in the license. You might be contemplating registering for copyright because you already own copyright anyways. However, like the importance of a license, registering your copyright is extremely important if any lawsuit is filed in court regarding your work. To be considered fact in court, you need to register your work within 5 years of publication. Also, copyright owners are eligible for financial rewards for their statutory damages and attorney fees if you register within 3 months of publication or before alleged infringement case began. To register your copyright, go to www.copyright.gov. You must include an attachment of your work, such as sheet music, and pay a $35 fee for registered works. A joint work is a work created by 2 or more parties. There is a lot of conflict when it comes to these types of works, if creators cannot come to an agreement. It is extremely important to create a split sheet on percentages and the final agreement before leaving a collaborative effort so the other creators do not try to take the entire copyright. Without a written agreement, it is hearsay in court. Also, many businesses will not work with you or pay you until all co-creators agree on an agreement. Licensing a joint work, any co-owner may offer full copyright under a non-exclusive license, although an exclusive license includes all parties involved. The Berne Convention was the first international agreement governing copyright. However, the U.S. didn't join initially. This convention really impacted copyright and still does. It provides creators such as authors, musicians, poets, painters, and more with the means to control how their works are used by whom and on what terms. The 1909 Copyright Act included new requirements to maintain copyright, including copyright notice, registration, and publication. In 1909, to register a work, you needed to complete registration at a patent office. Also, publication is achieved once making works available to the public. Copyright notice on work is no longer required, but used to be to clarify who owns the creation. To create a notice for a song, you'd use a copyright symbol, year of publishing, and the name of the copyright owner. Finally, in the 1972 Act, sound recordings were added to the copyright laws. Before 1972, they were not covered because people didn't think to add sound recordings. They only considered songs to be covered by copyright before then. Another great addition from this act was one of the 5 basic rights. The right to reproduce was added due to the start of pirating records in the 1960s and 70s. However, performance rights were not included because airplay on radios caused an increase in record sales at that time. Due to a huge rise in the U.S. of music recording exporters, the U.S. had to start thinking globally. Therefore, Congress was now trusted to manage copyright law. Many of the changes made during this act were to bring the U.S. closer to the Berne Convention. The first major change made during this act was the copyright term length was revised. The copyright term was updated to match terms suggested by members of the Berne Convention, therefore author's life plus 50 years. The next major change is the work for hire. A work for hire is work prepared by an employee within the scope of their employment or work made especially for commission for someone else. Another huge addition to this act was termination rights. Termination rights were made to balance corporate versus public interest. Termination rights were made to give creators a second chance. Imagine selling your copyright to someone only to find out that they're using your work for something that you don't agree with, and now you're stuck in a bad deal. Well, Congress gives you the second chance after 35 years to claim your copyright back. Therefore, after 35 years, the creator has a one-time chance to revoke their transfer of copyright. It is important to keep in mind authors must send a formal notice 2 to 10 years prior to termination point to be eligible to revoke the transfer. Also, creators can't revoke any existing licensing deals created by the copyright owner. Another important addition to this act was fair use. Fair use allows the public to use a reasonable but limited amount of a portion of a creative work. Although this is a legal defense in a copyright infringement case, the court makes the final decision whether the access was reasonable or not. The purpose of fair use is to advance learning, knowledge, and benefit the public. The 4 factors a judge must consider to determine if it is fair use is if the effect that the actual or potential market for the work, the nature of the copyrighted work, the amount or portion used, and the purpose and intent of the usage. The other major changes made during this act were compulsory license, works needed to be original, fixed and tangible form, and display creativity. Registration was no longer required, and copyright notice was now required on published works. All of these exceptions were all made to offset the impact of the new, longer copyright term of creator's life plus 50 years. In today's copyright, the 1998 Copyright Extension Act extended all U.S. copyright terms plus 20 years. They did not require renewals for creators' copyright again. Due to this revision, for works made in 1978 on, were now considered legitimate for creator's life plus 70 years. Also, if the work was co-authored, we would consider the last author's life for the date, then plus 70 years. However, for pre-1978 works, they are now considered legitimate for 95 years. This includes work for hires unless 120 years from creation expires first.